In this video, we will introduce the recent federal court decision in Knight First Amendment Institute v. Trump, and along the way, we will be discussing public forums and viewpoint discrimination. Now keep in mind that this decision is from the Second Circuit Court of Appeals, which is an intermediate appellate court decision from the federal court system. This is not a decision by the Supreme Court of the United States. The background to this case is that President Trump has a Twitter account, and there are some people who would follow his account and post dissenting views. They tweeted their disagreement with the president, and the president would then block those people so they couldn't post or follow him. On the other hand, people who approved of the president could follow him and post their supportive tweets. This led to a lawsuit in federal court in which plaintiffs argued that this violated their right to free speech. That is, the First Amendment to the United States Constitution prohibits the government from restricting free speech, and plaintiffs argued that the president violated their rights by blocking them on Twitter. The president argued, among other things, that this was not a problem because a Twitter account is private. It's his account, unlike a public sidewalk or a public park. And this is an important distinction, because in a private place, a private forum, a restriction on speech is usually constitutional. But in a public space, a public forum, a restriction on speech is usually unconstitutional. So, for example, a government office would usually be considered a non-public forum. And if someone from the government restricts a person's speech, it is probably constitutional. A restriction on speech in a non-public forum is usually permissible. But in a public forum, such as a park or a sidewalk, that's a place where everyone should be allowed to express their views. And if the government creates a public forum by opening up a place for discussion, such as if the government were to invite the public to come discuss their views on an education budget, then the government must allow different views to be expressed on that topic within that public forum. So the government can't throw someone out of a public forum because the government dislikes her views. That would be considered viewpoint or opinion discrimination. And in a public forum, viewpoint discrimination is unconstitutional. The federal court looked at the president's Twitter account and agreed. That account should normally be viewed as a private account. However, the court concluded that Trump made the account a public forum. Trump uses his Twitter account to express government positions, and he invites the public to interact with him, to tweet in response to the president's tweets. As a result, the Twitter account went from being a private account that happened to be owned by a government official to an open forum for purposes of the First Amendment. And therefore, if the president blocks a person from his Twitter account because he disagrees with that person's opinion, that's unconstitutional viewpoint discrimination because that Twitter account is a public forum. To summarize, an intermediate appellate federal court ruled that President Trump could not block people from his Twitter account simply because those people disagreed with the president. The court held that when a government official uses a social media platform for official purposes and creates an interactive forum, he creates an open public forum. And barring people from that platform because the government disagrees with them is unconstitutional viewpoint discrimination.